Black Americans can legally take back native land right now, not through protest, not through a political favor, not through a special program, through a legitimate legal pathway that most people have never been told exists. Across the United States, families long classified as Black are walking into courtrooms with faded census pages, church registers, and treaty-era records, and walking out with restored citizenship and land. Judges are not giving them charity. They are enforcing treaties. They are correcting racial erasure, and in case after case, they are returning property that was taken when indigenous ancestors were stripped of identity and renamed. This is happening quietly because it dismantles a dangerous myth that Black Americans have no legal claim to this land beyond the legacy of slavery. The truth is far more unsettling. Many Black families descend from Native Americans whose identity was erased so their land could be taken. Today, the same law that once erased them is being used to restore what was stolen. This is not a loophole. It is not wishful thinking. It is treaty law, federal statute, and property law doing exactly what they were written to do: recognize descent, enforce citizenship, and return land to the rightful heirs. The door is open, the records exist, and for families willing to prove their lineage, the land is not gone. It is legally recoverable. In this video, let's understand how.
The Black History Archives.
When the United States expanded across indigenous territories, it did so through binding treaties that recognized Native nations as sovereign political entities and guaranteed land to their citizens. These were not symbolic promises. The Treaty of Dancing Rabbit Creek, 1830, with the Choctaw Nation, the Treaty of New Echota, 1835, with the Cherokee Nation, and the post-Civil War treaties of 1866 with the Cherokee, Choctaw, Chickasaw, Creek, Muskogee, and Seminole nations all contained concrete guarantees of citizenship and land right. In exchange for cession and peace, the United States pledged protection, allotments, and political recognition. At the same time, the country hardened a racial system that tied Blackness to enslavement and indigeneity to a separate political status. That separation created a lethal incentive. If an indigenous person could be legally reclassified as Black, the state could deny they were Native, dissolve their tribal citizenship, and treat their land as unprotected. This strategy unfolded in slow motion across the South and Midwest. Indigenous families with dark skin were increasingly recorded as Black, colored, or mulatto in censuses, birth registers, marriage licenses, and court records. This was not clerical drift. It was a method. Once a person was legally Black, officials could claim they were no longer a citizen of a Native nation, void treaty protections, and open the door to land seizure. Railroads, timber companies, and land speculators then moved in, using probate manipulation, tax foreclosures, and fraudulent deeds that relied on the claim that the Indian owner no longer existed. In Indian Territory, the Dawes Act, 1887, and Curtis Act, 1898, broke up communal lands into individual allotments, promising protection under federal trust law. But when Black indigenous citizens were pushed onto separate freedmen roles or erased entirely, those protections were weakened or denied, enabling the rapid loss of allotment. Land did not vanish. It was transferred, papered, and normalized into the settler economy. By the early 20th century, thousands of indigenous families had been converted on paper into Black families. Their communities were declared extinct. Their lands were declared available. This is the original injury that today's claims address: identity erasure engineered to make land theft lawful. Now, what changed is not the law. What changed is our willingness to confront what the law was used to hide. Federal law has always recognized that treaty rights and tribal citizenship are political, not racial. The Supreme Court has repeatedly affirmed that Native nations are sovereign and that their citizens retain rights tied to treaties, allotments, and federal trust obligations. In Worcester versus Georgia, 1832, the court held that treaties are binding and that states lack authority to interfere with tribal sovereignty. In United States versus Kagama, 1886, and later cases, the court emphasized the federal trust responsibility over Indian land. More recently, in McGirt versus Oklahoma, 2020, the court reaffirmed that promises made in treaties remain the supreme law of the land unless Congress clearly says otherwise. This principle explains why Black Americans with indigenous ancestry are winning cases. In Oklahoma, descendants of Black indigenous citizens of the 5 tribes enforced the 1866 treaties, guaranteeing citizenship and land rights. In Cherokee Nation versus Nash, 2017, and related federal litigation, courts recognized that the Treaty of 1866 promised citizenship to the freedmen and their descendants. In 2021, a federal district court in Cherokee Nation versus Nash reaffirmed that promise leading to restored citizenship and the reopening of rights long denied through racial gatekeeping. When courts enforce treaties, they do not ask what color a claimant is today. They ask whether the ancestor was a citizen when the right attached. Here's a reminder to please support us so we can make more videos for you by subscribing to our channel and giving the video a like. We want to build a strong community and we need your support. Let's continue now. Outside Oklahoma, families reclassified under Jim Crow have reopened probate and quiet title action. In Virginia, where the Racial Integrity Act of 1924 and the actions of Registrar Walter Plecker erased Native identity, courts have voided transfers that relied on misclassification, restoring title to heirs who proved their ancestors were Native citizens at the moment land was allotted or guaranteed. In North Carolina, descendants of communities such as the Lumbee and other state-recognized tribes have successfully challenged tax foreclosures and probate sales by showing that lands protected by treaty and state recognition were lost only after racial reclassification. In Louisiana and Florida, heirs' property actions have unwound chains of title where guardianship abuses and trust violations stripped indigenous families, later recorded as Black, of their allotment. The door never closed. Racism tried to hide it. It should be known that courts do not return land because a story feels powerful. They return the land because a chain of legal facts is proven. Successful claimants connect 4 elements. First, a treaty or federal statute that granted land or protected an allotment to a specific indigenous citizen or family, such as the 1866 treaties with the 5 tribes, the General Allotment, Dawes, Act of 1887, or tribe-specific agreements incorporated into federal law. Second, proof of descent through records, censuses, church registries, freedmen rolls, tribal lists, probate files, and land patents, sometimes supported by DNA, only to confirm family relationships, not to prove race. Third, evidence that the ancestor's indigenous identity was erased through reclassification, leading to the loss of land. Fourth, proof that the transfer violated treaty protections, federal trust law, or state probate rules, rendering deeds void or voidable. When these elements align, judges can quiet title, restore trust land, and unwind fraudulent deed. Where land has been subdivided over generations, courts can consolidate interests and return large contiguous tracts. This is why the claim that Black people can't claim native land is collapsing. The law never required whiteness. It required descent. Racial erasure hid that descent. Evidence reveals it. Today, in Oklahoma, descendants of Black indigenous citizens enforced the 1866 treaties, securing restored citizenship and reopening land claims where ancestors were excluded after reclassification. Federal courts rejected blood quantum and racial appearance tests, emphasizing that treaty rights flow from political citizenship, not skin color. In North Carolina, families descended from indigenous communities labeled colored under Jim Crow challenged tax foreclosures and probate sales by proving their ancestors were Native citizens whose lands were protected at the time of allotment. Courts voided those sales and restored title. In Louisiana and Florida, heirs' property actions reunited families with land originally allotted to indigenous ancestors, later recorded as Black, allowing judges to correct chains of title broken by misclassification and guardianship abuses. These outcomes are not anomaly. They are the predictable result of applying treaty law and property law to facts hidden by racism. But if Black people reach the courts, how much land can be given to them? Well, indigenous allotments were were often 40, 80, or 160 acres per citizen. When an ancestor was erased and their allotment taken, that loss multiplied across generations. When heirs reunite and prove the original right, courts restore the entire allotment. Where multiple siblings' allotments were lost through the same racial strategy, restored acreage aggregates into large tracts. The scale is not generosity, it is arithmetic, finally honored by law. But what should be done to get the land back? The path begins with history, not hearsay. Families identify specific indigenous ancestors using censuses, church records, freedmen rolls, treaty lists, and tribal registry. They trace lineage forward to the present. They locate the land and reconstruct how it left the family. They file claims grounded in treaty enforcement, quiet title, and probate law, supported by evidence that reclassification caused the loss. This work is demanding. It takes patience, legal counsel, and archive. But it works because the law recognizes what racism tried to erase, that citizenship and land rights flow through families, not skin color. Today, individual families can win cases. However, communities win movement. Japanese Americans secured redress for wartime internment through the Civil Liberties Act of 1988. Not because one person sued alone, but because communities organized, documented harm, built legal strategies, and forced the government to confront its own record. Unity turned memory into law. Black Americans reclaiming indigenous land must do the same. When families work in isolation, records remain fragmented. When communities organize, they reconstruct entire lineages, connect overlapping allotment, and expose systemic patterns of reclassification. Courts respond differently when they see not one erased ancestor, but hundreds linked by the same racial strategy. Community means shared archives, legal defense funds, research teams, and public accountability. Elders, genealogists, and attorneys working together to confront the institutions that erased us. Black Americans can legally reclaim native land today because treaties remain the supreme law of the land. Courts are enforcing them. Families are proving dissent. Communities are organized. And the erasures of the past are being confronted with the only language powerful enough to undo them, the law. This is not a moment, it is a movement, and it will be won by a united community who refuse to let their history remain stolen. Tell us, how many acres were taken from your bloodline while you were taught you had no claim? Would you fight to get your land back? In the comments section, share your thoughts on whether a large and powerful community should be created to build a powerful case in the court to get the native land back. Would you like us to make more videos? If yes, please support us by subscribing to the Black History Archives and clicking the bell icon. You can check out more videos on our channel too.